Today's video, I want to talk about a case that's going to be argued before the Massachusetts Supreme Court next Friday called Commonwealth versus Thomas Gearhart. And the reason this is an important case is because it addresses the issue of how do you prove someone's impaired by marijuana when they're driving on the road. And what the government has been doing in these cases is using the field sobriety tests, one-leg stand, 9-step walk and turn. And these tests were originally designed for alcohol impairment. They've been studied for alcohol impairment, and while they have their issues about how accurate they are even with regard to drinking, they at least were studied, and there's at least some support for the idea that if you can't balance on one leg or you can't walk out 9 steps, that you might be impaired by alcohol. There's never been any study or suggestion or any relationship to whether someone's under the influence of marijuana in terms of how they're going to do on a 9-step walk or turn or one-leg stand test. So these tests don't have any scientific validity or any correlation to whether someone's impaired by marijuana. So when the issue came up, it came before a judge in the Worcester District Court, and he found that you can't admit these tests in an OUI marijuana case because they aren't reliable. And that ruling is going to be challenged in the Massachusetts Supreme Judicial Court. I think the judge's decision was very well reasoned, and I think it's going to come out in favor of the defense because it's really unfair to allow the government to present this evidence in front of a jury, and the jury's going to understand the background of how these tests are used with regard to alcohol and assume there's that same reliability with regard to impairment by marijuana when there's really not a sufficient basis in the scientific literature to support that connection. Second issue in the case is whether police officers can testify and give a lay opinion that someone's impaired by marijuana. With regard to alcohol, a police officer can say the person looked drunk, and the reason is because people are familiar with the signs of being under the influence of alcohol. With regard to marijuana, there's really no specific clues or indications that a lay person can make to conclude someone's impaired or under the influence of marijuana. The court said, looking at various studies, the judge in the Worcester Court said that lay people really aren't as familiar with marijuana as what would be required for us to allow lay opinion into evidence. So what that means is the officer would then have to be qualified as an expert to get that opinion into evidence. So those are the two issues that will be addressed by the Massachusetts Supreme Court. This case will have an important impact on how OUI drugs or OUI marijuana cases are prosecuted in the court, and I expect on both grounds the defense should prevail, as I think the law and the science doesn't support any connection between the field tests and being impaired by marijuana, and officers simply don't have the training to come to that opinion without being qualified as an expert or further training. Now, the expert training may not be available. The officers will probably have to be retrained, as the DRE protocol that is used to determine whether someone's under the influence of drugs also relies on field tests. So this decision will have an important impact on how OUI marijuana cases are prosecuted in court, and the oral argument is this Friday. If you have questions, feel free to contact me. My name is Michael Del Signori, OUI defense attorney in Massachusetts. I handle these cases throughout the Commonwealth. Be happy to talk to anybody and explain the law in this area.